Next case on the report is Kevin Hall. I guess you don't have to dodge it, you're still here.
Yes, sir.
Morning. You both will have 15 minutes to present your arguments. The appellant may start up to 5 minutes. And we're ready to brief, so we're ready to proceed.
Morning, Your Honors. May it please the Court. My name is Christina Smith-Rott. I'm here to argue for the defendant appellant Kevin Hall in this particular matter. As the Court is already aware, we assigned 2 assignments of error in this particular case. The first assignment of error directs the manifest weight sufficiency of the evidence. It's a very common argument in criminal cases where there was a trial. In this particular case, the main issue on the sufficiency and the manifest weight claim is simply that there really wasn't enough evidence presented as to, especially one of the dogs, the white dog. There's a small terrier by the name of Camille. There's no picture that was very clear as to the condition of that dog. There's no specific testimony of that dog. The testimony all relates generally to all 3 dogs. And when somebody, of course, says the dogs were emaciated, the dogs had their ribs sticking out, well, typically they're not all the same level. We group things together when we're talking about something, and we lump them together, even if one dog was particularly emaciated and the other ones weren't. We might say, well, I could see his ribs a little bit, but that other dog, well, we're just lumping them together. So in this particular case, as to the conviction relating to failure to provide a wholesome amount of food and water, obviously the question is, was there somebody going to that residence every day? Were these dogs being provided that wholesome amount of food and water? And as to sufficiency, well, of course, if dogs are very, very thin, there's a question. Do they have a health condition that's causing them not to gain weight, even if they do have food and water?
They were sufficiently thirsty to consider the matter of the water.
Correct, Your Honor. There is testimony that they did drink, I think it was actually 2 gallons of water at one time, and one of the witnesses did state, Your Honor, that it is unusual for dogs to want to drink that much. But from the defendant's perspective, which dog drank it? I mean, I hate to be that particular because it almost sounds callous, but that's the point legally is you sit there, you give these dogs 2 gallons of water. Did the 2 black dogs drink it? Did the white dog drink it? Did all 3 of them drink it? We don't know. There's no testimony as to whether all 3 dogs were having problems or whether it was just one of the dogs that was particularly thirsty. The evidence also shows that these dogs were capable of going inside to a specific area in the house, and there's no testimony about whether there was ever anything in the house. Nobody looked in the house. Nobody saw whether there was food and water available. People did testify that it was obvious somebody was coming to and from the house at least one time because things had been removed from the porch. And did he feed and water the dogs at that point in time? The other argument, unless there's another question on the sufficiency, manifest weight on that one. The second argument in this particular case, Your Honors, has to do with the abandonment issue. There's very little case law in Ohio on the specific question of abandonment. Apparently this, thankfully, does not come up very often to the appellate courts. In this particular case, the only cases I could find related to abandonment are a civil case, which does deal with the breach of a contract, as well as the question of does the definition of abandon apply to a horse, where there was a civil contract, one of the parties said, come get your horse, I don't want the horse anymore. The other party said, the other party didn't come and get the horse, but sued over the horse because I think they wanted something other than just the horse. They also wanted to be paid for a certain value, plus as well as there was a halter that may or may not have been returned to the horse when they were getting it. But the case law in that case specifically said that you have to show an absolute affirmative proof that they intend to totally discard this animal, that they are not coming back, that they are not going to do anything with this animal going forward. And although that is a civil case, there's also one criminal case, State v. Amos, that also states that same standard. You have to show affirmative proof of a total intent to discard the property. In this particular case, although Kevin was not there when people were coming to the property, it was obvious that he was coming to and from the property during those 3 days when the humane officer and the neighbor were coming over.
I can't remember. Was there any testimony that he
don't believe there was any testimony about what was still in the house. There was only testimony, to my recollection, as to there were things on the porch, and those things had been removed at one point in time. There was also testimony that the door knocker information sheet that was left by the Humane Society the first day had been removed, but there's also no testimony as to whether my client removed it or did the landlord remove it, because it's obvious that the landlord also came and was present at the property. His name came up several times in this particular case in the testimony. So that's the big question on the second assignment of error, Your Honors, is whether or not there is that affirmative evidence that he really totally intended to not come back and claim his dogs, when he was in fact coming to the properties, and the testimony was clear that he was coming to the properties even though nobody had specifically confronted him at the property.
There's an argument in the brief in response to the state's position that abandonment could also be inferred from the fact that the client did not claim the animals sometime after the date in the complaint.
Correct. I did raise that argument as well because, of course, that's the second question, is did he in fact abandon them at a later date when he did not go into the Humane Society after the Humane Society had notified, I believe it's his cousin, he called a cousin and said, by the way, let your cousin, the defendant, know that we have these dogs. And there's two problems with that, Your Honor. The first problem is that the charge in this particular case, the original charging instrument says he abandoned them on, I want to say it was the 27th, something along that line. And they didn't argue at that time that we're talking about abandonment at a later date, but he didn't go with the Humane Society. The second problem with that, Your Honor, is that by that time, he's aware that somebody else has become the caretaker of these animals, has voluntarily gone out and said, I am taking over the care and concern for these animals.
And how's he aware of that?
I don't want to assume anything, so I can't say it that way.
Well, and that's the point.
Correct.
Because if you assume that he's aware of it by virtue of having claimed the notice, then that has other implications.
And I don't know whether he's the one who took the notice, but I do know that there was testimony, I think it was on the second or the third day, that the officer spoke instead to his cousin. I don't remember the name of the cousin off the top of my head, but there's testimony that he spoke to my client's cousin and said, by the way, we have these dogs, would you let him know? There's obviously an issue here, please get in touch with him, have him get in touch with us. So even if we have no idea whether he actually claimed the written notice, it seems fair to believe that his cousin would have called him and said, by the way, your dogs are being cared for by the Humane Society.
And so your position is that, well, they're receiving care from somewhere.
Correct. Somebody else had taken over the care at that point in time. He was aware of it. And so he's not abandoning them without care. He is allowing somebody else to take over their care. Unless your honors have any additional questions.
I don't think so. Thank you.
Thank you.
Thank you. May it please the court again, my name is Olivia Boyer. On behalf of the state of Ohio, the appellee in this case, and again, I'd like to start with the facts that were established at the trial court level, which led to the finding guilty of Mr. Hall. We had here 3 dogs, 2 of which were black dogs of medium size, and also a small dog that appeared to be some type of terrier comparable to a Jack Russell Terrier. And on August 27th, there was a complaint of a neighbor who rented a barn near Mr. Hall's residence that drove by, saw the animals, and testified that she thought they were walking skeletons. And that's what prompted her call to the Wayne County Humane Society, specifically Wayne County Humane Society agent Diane Hudson, to respond to the scene. Ms. Hudson testified at trial court level that when she initially appeared to address and observe these animals, that she found them to be emaciated, that there were observable food dishes and assumedly dishes for water that were completely empty. Again, we're talking in the middle of summer, August, heat, and that they were confined. These animals were caged and weren't able to leave the area. Ms. Hudson also testified that there appeared to be a door, and Ms. Reinhold alluded to that, However, given the state of the animals, I'd say there's strong circumstantial evidence that the animals did not have access to sufficient or wholesome water or food, given their emaciated state. Both dogs, the two larger comparable to black lab mixes, gained over 10 pounds each once in the care of the Wayne County Humane Society. And there were also photographs, which I believe the court has before it, that were submitted as exhibits, showing the before and after photos of these animals. These animals did not have access to wholesome food. They did not have access to wholesome water, and that's evidenced by the state they were in when Ms. Hudson appeared. Ms. Hudson also testified that she went back on the 29th to observe the animals after providing them a couple gallons of water, and that she provided them food and that they eagerly ate it. Now, if these animals had access to wholesome food in sufficient amounts to satiate their hunger, they wouldn't have eagerly devoured the food that Ms. Hudson had to throw over and provide to these animals. Now, I'd like to draw the court's attention to the case State v. Amos, a case cited by the appellant arising out of Ashland County. In that case, the defendant, Amos, trapped a feral cat, a cat that was believed to be feral. Its eyes were matted, it was severely emaciated, it was crying, and it was a kitten. And Ms. Amos had trapped the animal because she had had issues with her porch before with other cats getting underneath the porch, causing an odor once they died and their bodies were left behind. So Ms. Amos didn't want that to happen again, trapped the feral cat, and was observed by an employee of a vet clinic in Ashland County to be dropping off the cat at the vet clinic, assuming that the vet the next morning would discover it and take care of it. However, in that case, the trial court, based on those facts, a feral cat being trapped, being in the possession of the owner for less than 24 hours, it was one day on July 2nd where she dropped it off, that was sufficient to affirm the trial court's finding of guilty in regards to abandoning an animal. Here, we have greater facts connecting Kevin Hall to the abandonment of the animals, as well as prohibitions against companion animals, in that he did not provide them wholesome food and water. That connection being that the neighbor testified that she was aware Mr. Hall had resided there, that he was in the process of being evicted. Ms. Hudson made contact with the landlord who testified that he was pursuing the eviction process. Ms. Hudson testified that she had been told, the landlord didn't testify, but Ms. Hudson had been told that the eviction process was being pursued against Kevin Hall. The neighbor testified that she believed someone was coming and going, that there were notices posted. Ms. Hudson testified that she put a notice on the door alerting the owner that there was an issue with the animals, and the animals were left there after the initial visit from Ms. Hudson. So the defendant, appellant, had an opportunity to remedy the situation with the animals by providing them with wholesome water, but he did not do so. He abandoned the animals after there was notice put on the door notifying him that there was an issue. Now, comparing the facts we have here with Amos, I believe that the state did present sufficient evidence to the trial court to find that the state had proven beyond a reasonable doubt every element of the offense. Now, it's not been contested, the jurisdiction, of course. I don't believe there's a question that there was sufficient quantities of good, wholesome food and water. And I'd also draw this panel's attention to the testimony of Stuart Mykrantz. Stuart Mykrantz is the executive director of the Wayne County Humane Society, and while he did not go to the residence where these animals were found, he was involved immediately afterwards with one of the animals, I believe, named Boston. Boston was of such deteriorating health that they thought they were going to lose him, that he was going to die, as testified to by Mr. Mykrantz, and that they had to put intravenous fluid into Boston's body so he could get nutrition. Now, appellant has taken issue with whether or not that is sufficient evidence to establish that there was, it's commonly known as cruelty against a companion animal, or prohibitions against a companion animal. And that element, the state must prove beyond a reasonable doubt that the defendant, that it was reasonably expected that the companion animal would become sick or suffer in any way as a result of or due to the deprivation. Here we have the direct deprivation of wholesome food and water of sufficient amounts to satiate these poor creatures. And that's what we have here. Now,
I respond to the inquiry about testimony kind of lumping together the dogs, because that is significant where there are three separate counts.
And I would agree, Your Honor, and I would draw the court's attention to the same exhibits that the trial court was able to review. When the McWayne County Humane Society took the animals in, they took individual photos of the animals, the two black lab mixes as well as the smaller terrier animal, and I think it's clear from those photos that were submitted to the trial court's review that each individual animal was being deprived. All of these animals were extremely underweight. They were able to gain a substantial portion of their body weight back once in the care of the Wayne County Humane Society. Looking at those photographs and taking those into consideration with the environment that the Wayne County Humane Society agent Diane Hudson observed them in, I think the trial court correctly was able to determine that all three animals were being deprived of wholesome food and water.
So what was the actual evidence in regard to white water?
The white
Photograph, you said.
Yes, there was a before and after photograph. There was also weights taken at periodic times while the animal was in the care of the Wayne County Humane Society. I believe that particular dog gained, I don't recall the exact number, but it was a little less than 10 pounds, 7 pounds of its own weight back. And if you look at the dates, the weight gain for Camille, the white terrier that was referred to by appellant, was immediate. Now, the other two lab mixes had issues, given that they were, that one, Boston had to get an intravenous fluid in order to bring him back to the point where he could consume food. And the other one, there were also concerns of parasites and infection and things like that, so they were given antibiotics, medicine appropriate for the animals. That was testified to by Stuart Meinkrantz, the executive director. But once the medication was given to the animals, you see an immediate weight gain.
But, and of course, we'll be examining all the evidence because we haven't had access to it yet, to the physical documents and so forth, physical pictures. But I guess my question is in regard to that. I don't know that it's sufficient necessarily just to say we have weight gain because I can feed my dog more food and she get to gain weight. Was there testimony that they were malnourished and underweight?
I believe that was referred to by Diane Hudson, and I would draw the court's attention to the testimony of the neighbor, who's a layperson. I can't recall her name off the top of my head, but Brenda was the individual who rented the barn. She described the animals as walking skeletons. I think a layperson observing those animals in such a state is sufficient to establish that they were deprived food. If you look to what the statute says, and of course we're looking at the 2013 of the statute, version of the statute that was effective, of course, effective up until September 29, 2013, it's a question of can it be reasonably expected that the companion animals would become sick or suffer in any way. It's not that it has to be established that they were suffering, which is different, I believe, than the statute we're under now, but it's a question of whether or not it can be reasonably expected that the companion animal will become sick or suffer. And these animals were sick. One required an IV in order to avoid death. And I would strongly encourage this panel to look at those photographs and just see what state and the condition that these animals were in.
I have just one clarifying question. There was a dog door between the outside and the inside of the house. And I presume it was working for the animals to go inside the house if they chose to do so, assuming they're good enough to do that.
Yes.
And then so many facts here, but was there water and food left inside the house?
I cannot say definitively whether or not, based on the evidence that was presented at the trial court.
Correctly got into the house door.
Correct. There was not a warrant obtained to enter the home at this point. However, I would say that there's strong circumstantial evidence that the animals did not have access to food and water in the home, given their emaciated state, given the weights, given what was observed by Diane Hudson when she testified that these animals gobbled up water and food, and that at one point when she initially observed the animals on August 27th, she didn't have food on her to provide these poor creatures. She attempted to give them treats, but that they began fighting over the treats, and so she had to lob them over the fence for the animals to give them something, anything she had on her. And that later, when she returned and provided them food, they immediately ate it. And it could be argued, given the state that Boston was in when the Wayne County Humane Society took care of him, that but for that action, these animals wouldn't have made it, and we would have a different case here. But the animals did survive. They did have emaciated physical status, and that was observable by any layperson looking at these animals. I'd also like to discuss the case that was cited by appellant Carver. And yes, that case is a civil case, and I would agree with appellant that there is a dearth of case law for animal cruelty cases such as before the court. But the facts of Carver are extremely different than the facts we have here. Carver was a civil case of disagreement between a boarding house of horses and an individual who was boarding the house of the horses at the facility. And that disagreement arose because there was a negotiation with the seller of the horse trying to sell the horse to get boarding for other horses, and the horses were removed. And there was an argument that the seller of the horse or the purchaser of the horse had abandoned the animals because he hadn't picked up the animal. That was the only basis for the allegation of abandonment, that the animal hadn't been retrieved. Here we have more than the fact that Kevin Hall, the appellant, didn't retrieve the animals after notice was posted that they were in the custody of the Wayne County Humane Society. We have him coming and going from the home, being evicted, moving out of the house, removing property, but not taking the animals, not providing for their care. And I don't believe that we can overturn the conviction for abandonment on the basis that he assumed the Wayne County Humane Society took care of it and that was sufficient, especially looking at the facts of State v. Amos, where a well-intentioned woman dropped off an animal, did not notify anyone at a veterinary clinic, and then left. That was sufficient for a finding of guilty for abandonment, and the appellate court upheld that finding. Given that, I believe the state established at the trial court level that there was sufficient evidence for conviction of cruelty to companion animals or prohibition against companion animals, as well as abandonment of the animals. And if there are no further questions from this panel, I will rest.
Thank you.
Thank you.
Yeah.
I do believe that once you get the evidence in this case and you see the pictures, when I looked through the file, I only found 4 exhibits, and there are not pictures of the dogs afterwards. There are the pictures of the 2 black dogs for sure. In their condition, there's a picture of all 3 dogs together, including one dog that is not very clear. I can't recall off the top of my head whether the 4th picture is a duplicate of one of the black, not duplicate, but another one of the black dogs or not. I also wanted to point out to the court that these animals were not caged in the essence that they're not in small cages. They're in a large dog run with, as the court noted, access to the inside, but unfortunately we have no idea what's in there. The second thing I want to point out is although there was testimony that one of these dogs was so bad that he was dying, there was an objection that was sustained on that matter. So that his opinion that the dog was dying, the court thought he was not, the gentleman who gave that opinion was not trained enough in medical situation to say that he died, he's not. And that's fairly nitpicky. But I did want to point out to your honors, especially as to State versus Amos, that when the court considered the question of whether this elderly woman had abandoned the kid, one of the things they primarily relied upon was that she didn't avail herself of methods of having the animal removed and its injuries treated. She said she asked people to help her, but nobody was helping her. In that particular case, this is a woman who takes an animal and leaves it in a place where it's likely not going to be found for at least 18 to 20 hours. She knows it's in a very, very poor condition. She leaves it and she doesn't contact anybody to find out what happens the next day. She doesn't leave a note. In the case of my client, it's a little bit different than that, simply because he knew those dogs already were taken over by somebody who was caring for them. So he didn't abandon them in that he was going to home those days. And that,
Well,
yes.
you're saying that he knew after the notice was posted that someone was caring for him.
Correct.
But in order for the dogs to, assuming that the trial of that would leave the emaciated condition, something had to happen before that time. Correct.
As in,
Well, they didn't reach that condition overnight.
correct. If you look at the pictures in the testimony, you find that all 3 dogs were emaciated and all 3 dogs have problems, then correct, something could happen prior to that. Dogs generally don't get that emaciated overnight if they truly were walking skeletons, which again, I think when you look at the pictures, you can make that determination yourselves. There was also some testimony about the dog food and how fast they eat the dog food, and if any dog owner is aware, dogs are going to fight over treats. Doesn't matter whether they're full, they're not full, they're going to fight over treats, they're going to eat pretty much every food you put in front of them, or at least most dogs will. So there's an issue there. There was actually testimony about that. One of the officers did testify that yes, that is true, that it's the water that was more telling than the dog food in this case. Unless your owners have any other questions,
I don't believe so.
I would just ask your owners to consider the argument that's made and find favor of the defendant. Thank you.
The court will take the matter under advisement and the will be sent to both sides, and also you can check on the Supreme Court website and on our records.